At the core of this bill, it's about accountability and constitutional structure. You probably are all familiar with the 10th Amendment that reserves to the states the powers not delegated to the federal government. And whether you lean, well, I guess whether we're leaning conservative, I guess I don't have to speak to the other side at this point, or even if you are progressive, the principles remain the same. The states are non-administrative agents of Washington, D.C. We're sovereign partners, though, in a federal system. And over the last several decades, federal regulatory agencies have increasingly relied on states to enforce federal rules, often without direct legislative approval at the state level. In some cases, probably many, the enforcement mechanisms are adopted through state agencies' rulemaking rather than through an act of the General Assembly. And I recall about, I think it was 2014, when I first became aware of this situation. I looked into it to see what actually was done by the Joint Committee on Administrative Rules, or JCAR as we refer to it, and I was a little bit surprised. Y'all probably remember Cindy Cadillac. She was the attorney who represented JCAR at the time, and so I sat down with Cindy and asked her to help me understand what JCAR was all about and what they did, and she said that they typically see about 1,800 rules a year, and that surprised me. I then took a calendar, took off all the holidays and weekends, divided that by the 1,800, and it came up to about 7+ rules a day. Now imagine, if you will, we're in the setting here, and you have 7+ rules every day that you meet, set aside the weekends and holidays, and you've got to determine whether they should be approved or not. Then I asked Cindy, when was the last time they met, JCAR? She said, been about 8 months. Multiply 8 months times probably 20 or so, 160 plus times the 7. That's a ton of regulations and rules, whether they're coming from the state agencies or the feds, that didn't get the time of day. And gentlemen, these rules affect you and me every day, whether you're a businessman or a farmer or just an average citizen. These are things that ought to be held in check by the state legislatures. Now, what Senate Bill 1030 does is requires that Missouri departments and agencies enforce federal regulations within our borders, but that enforcement must be approved by the General Assembly. It also requires that any new state rule or adopted or in conjunction with enforcing federal regulations after the 28th of August this year, when laws go into effect, receive legislative approval before being enforced. Also, it directs the Committee on Administrative Rules to review existing rules tied to federal enforcement and make recommendations to the General Assembly regarding whether those rules should be continued. And you may have heard the term anti-commandeering. It's a pretty simple concept. It dates back to the 1800s in the United States, and even up to probably 2 years ago was the last time that the U.S. Supreme Court heard a bill or a case that essentially would require states to enforce federal regulations. It's not an idea of nullifying federal regulations necessarily, but it's whether or not the feds can force the regulation to be enforced using state resources. That's at the crux of it. And so that's essentially what, and I should say the Supreme Court upheld the states' rights, saying you don't have to use your resources to enforce these federal regulations. It's up to the feds to do that themselves. That's really the crux of this bill.